Hi guys, I am Ayushi, your mentor for law entrance exams, and welcome to Law Digest. In this video, we are going to cover legal current affairs for the month of February. I know it's a little late, but better late than never. अगर आप ऐसी वीडियोस के नोटिफिकेशन ऑन रेगुलर बेसिस चाहते हैं देन और इफ यू आर न्यू टू दिस चैनल देन डू सब्सक्राइब टू दिस चैनल, hit the bell icon, hit the like button, share this video with your friends, and if you're from the legal fraternity you can further share it in the fraternity. Now, starting with the first case, so as usual, we are going to cover some of the most important observations or cases or judgments of the month of February in this particular video. Apart from this, there are other several important judgments that are already covered in my legal current affairs module available on our website. Starting with the first one, State of Maharashtra versus Amit Shrivas. What is this case about? Now, in this case, the court dismissed the review petition. Which review petition? The petition that was filed against the Shaheen Bagh judgment. And what did it hold? It held that the right to protest cannot be anytime and anywhere. So it says that people cannot just sit out on roads and start protesting anytime and everywhere. So this is not a right that is available to them. This right is not really available to them all the time. And a review petition that was filed against the Shaheen Bagh judgment, which also held that people do not have right to protest like this, that review petition has been already dismissed by the court. Moving further, let's look at the second important legal development. Now, what happened was that Ajit Mohan, who is the vice president of Facebook, he was issued summons by the Delhi Assembly to inquire into the Delhi riots. It was said that Facebook has been involved in the Delhi riots, that they have caused these Delhi riots, and that is why the VP was issued summons. Now, what happened was that Tushar Mehta, keeping this particular thing in mind, the Solicitor General of India, Tushar Mehta, he was representing central government in this case, and he informed the Supreme Court that there are a lot of problems that are emerging from social mediums like Facebook, Twitter. We already see that so many things keep getting posted, and there has recently been a series of cases with respect to contempt that has taken place on Twitter. So he was of the view that it is an uncontrollable global problem, and this problem cannot be legislated upon by the state assemblies. The state assemblies cannot actually make a law on this problem. So he told the court that this issue of national level should be taken up by the parliament. So the court should give directions in this case, should give such direction in this case that these issues can be taken up by the parliament. Then moving on to the next one. Next is Gajanan Babulal Bansode versus State of Maharashtra. Now, what happened here was the court said that recruitment of candidates in excess of notified vacancies will be in violation of Article 14 and 16 of the Constitution of India. Now, firstly, Article 14 deals with your right to equality, and 16.1 says that reservation can be made in jobs for backward classes where they are not adequately represented. So the court said that whenever any vacancies they come out through a notification, those vacancies have to be kept in mind while granting reservation, while granting recruitment. It cannot happen that if the vacancies that were notified were 50 seats and that you exceed those vacancies and you grant 51 seats, that will be violative of these articles of the Constitution of India. If you're appearing for any law entrance exams, then Article 14 and Article 16 you must know from the point of view of this judgment. Then moving on to the next one. Next issue is with respect to the UPSC exam. Now, you must be aware that due to COVID, UPSC exams got delayed and a lot of exams got delayed. So there was a contention by various parties, and it was said that they should be given an extra chance. Now, central government, what happened was that in this case, the central government informed the Supreme Court that, okay, we have agreed to grant them one-time relaxation to prospective candidates who had given their UPSC attempt in October 2020 and were not age barred. So it will be granted to those people who had given their attempt in 2020 and were not age barred, and this extra chance would be given only limited to the year of 2021 and not after that. And it would only be granted to those candidates who had given their last attempt in the year 2020 and were not age barred. But on the whole, when the court took up this matter and viewed the matter, the court observed that the rules of recruitment that are there, they clearly say that no relaxation will be given for the age barred candidates. So the court said that we cannot undo the rules. If the rules provide something specifically, that cannot be undone, and it is within the realm of the executive to take any policy decision. Central government is the executive. They can take any policy decision, and the court cannot really say anything in this matter, and the petition was finally dismissed in the matter. So this is it, and after this we're looking at the last case here. The issue is that there were petitions that were filed in the high courts for regulation of over-the-top platforms, OTT platforms like Netflix, Prime, Disney Hotstar, etc. And there were certain cases pending, and this petition was filed to transfer the cases from High Court to the Supreme Court. Transfer petitions are filed before the High Court so that matters can be transferred from High Court to the Supreme Court. The center has indicated that it will bring guidelines to regulate. Now what happened was that center has indicated in this case that it will bring guidelines to regulate these OTT platforms, because in the recent past also there have been certain cases involving certain series. Tandav, as you know, has been banned and removed from the OTT platforms, and several controversial series that have come up. So center feels the need that it needs to regulate these OTT platforms. The kind of content that is streamed on such platforms needs to be regulated. Now the center has said that since they are out of the Central Board of Film Certification, they are not within the framework of film certification, the center will try to bring these platforms under the Cinematograph Act. With this, we come to the end of this video. Just in case you have any further doubts, queries, or you want to share something, you can mention the same in the comment box below.